Welcome to this morning's session of the Appeals Court. Our case at the moment is 2020 P0948, which is the Commonwealth versus Jose Garcia. I'll turn first to argument for the appellant. Mr. Weber, you may proceed when you're ready.
Good afternoon. May it please the court, Robert Weber on behalf of the defendant appellant Jose Garcia. Mr. Garcia was charged in a 7-count indictment, 1 count of trafficking heroin, 200 plus grams, 1 count of trafficking cocaine, 200 plus grams, 1 count of possession with intent to distribute heroin, 1 count of possession with intent to distribute cocaine, 2 counts of a drug violation near a school, finally 1 count of furnishing a false name to a public official. The possession with intent counts were dismissed, and after trial, Mr. Garcia was convicted on all other counts. Mr. Garcia has presented a 3-issue appeal. The first is that, and probably the most important issue, that the trial judge erred in denying Mr. Garcia's motion to suppress the evidence. The second issue being that this court should grant a new trial because the verdict was against the overwhelming weight of the evidence presented. And then third, that the trial court erred in denying Mr. Garcia's motion for a directed verdict as to count 7, the furnishing a false name to a public official. As I just stated, the denial of the motion to suppress the evidence, I think, can fairly be characterized as the most important issue in Mr. Garcia's appeal. In his motion to suppress, Mr. Garcia argued that the search was not supported by probable cause, specifically arguing that the affidavit submitted by Worcester Police in support of the search warrant was insufficient to establish probable cause for the warrant. Mr. Garcia's position that the affidavit submitted simply did not contain enough information for the magistrate to determine that probable cause existed under Commonwealth v. Reddington, 395 Mass. 315, 1985.
Mr. Weber, can I interrupt with a question? This is Judge Kinder.
Yes, Ron.
Do you agree with the general proposition that deficiencies in information provided by a confidential informant as to the veracity and source of knowledge of the informant can be cured by other corroborating information?
Your Honor, I do. I certainly agree with that. I believe that that's the overwhelming weight of the case law establishes that pretty clear.
Let me ask a follow-up question. In this case, why don't the 3 independent controlled purchases supply sufficient corroboration?
Your Honor, I think that with respect to the 3 controlled buys, the officer submitting the affidavit chose to leave out some very important information. 1 being the location of the buys, 2 being the amount of heroin or drug given to the confidential informant, the 3rd being the amount of money the informant returns to the officers with. I think these are all very important facts that were omitted from the search warrant affidavit. The officer admits that he admits these facts in order to protect the identity of the confidential informant, but I think that, as we stated in our brief, that his prerogative to omit that information if he feels that it's necessary to protect the identity of the informant, maybe for future investigations, maybe to protect that person's safety. However, he did so at his own peril in this case because essentially what he presented to the magistrate was, we have this confidential informant. That person is reliable because informants, not this informant, informants have led to arrests in the past, that this informant has admitted to past drug use, therefore is reliable, but he leaves out so much other corroborating information that how could other than the fact that informant met with someone that the informant explained was Flacco, in this case believed to be Mr. Garcia, and then returned with drugs. That's all we have here. There's nothing else.
Well, sorry, Mr. Weber, this is Catherine Hand. Sorry to interrupt, but they also had the fact that the police observed the entire transit to and from, and that at least on 2 occasions, the Flacco went from the house at issue directly to the purported drug sale and then directly back, all while being observed by the police into the apartment that was at issue, right?
Well, I believe 2 of the buys were directly from the apartment. One of the buys, they did not view him from the apartment to the meeting with the informant. But what I would say about that is, if you're gonna leave out location and amounts of the drugs, amounts of money, I don't think it's enough for the police to say, yeah, we followed him and we followed the informant to the Vi, and neither one of them stopped or saw anyone in between or, you know, had any chance to pick up drugs somewhere else or pick up money somewhere else. So I just think that because there are so many holes in the affidavit, it just didn't provide the magistrate with enough information to establish probable cause. And I understand that they're trying to link 202 Millbury Street to the drugs because that's where they got the search warrant for, but they could have easily vehicle as well, but they didn't because I don't think they knew where the drugs were. I think that this was a kind of a fishing expedition. They were not required to provide all the information, but certainly required to provide more information than they did. Not even to provide the location of the deal, to establish, for instance, the route Mr. Garcia took from the home to the meet, the route that the informant took from wherever they first met that person to the meetup.
Attorney Weber, it's Catherine. Sorry, Attorney Weber, it's Catherine Hand again. Sorry to interrupt. But have any of the cases that we have in Massachusetts discussing drug delivery operations required that level of specificity?
Oh, actually, yes, Your Honor. I think there are 3 cases that establish that when the place to be searched is a residence, there has to be specific information in the affidavit and reasonable inferences a magistrate may draw to provide the nexus between the drug selling activity and the residence.
I agree with you on that. But with respect to the information that was included here about where the travel by the ostensible dealer to the and from the place of the controlled buy is monitored, and where the place of origination is the apartment, hasn't that in the past been sufficient under where there are, in this case, 3 controlled buys?
I think the difference here is that Mr. Garcia gets in his car. No one asks to search the car. The officer in his affidavit states that he spent several hours of surveillance at Mr. Garcia's property, and did he witness any drug-related activity at the house? The only drug-related activity that he relates to the house is Mr. Garcia leaving and then meeting up with the confidential informant. And it has to be said that the assumption is that Mr. Garcia gave the informant the drugs because the officer has stated in the affidavit that they checked the informant, and then the assumption is the only way the informant could have got the drugs was from Mr. Garcia. But the bottom line is the affidavit doesn't even mention that they saw a handoff from one to the other. The affidavit doesn't mention that they saw the informant hand over the money, that they saw Mr. Garcia hand over drugs. Completely silent as to those facts, that I think are very important, especially if the police are performing surveillance on both individuals all the way up to the meeting point. Why don't they have eyes on the exchange of anything? They just have eyes, they just meet.
So what's your best case? This is Judge Henry.
Yes, Your Honor. What best case with respect to?
For why we should suppress, because we have Commonwealth versus Klagen, which is the Supreme Judicial Court, and there they, even without a statement from the informant tying the home to the drug dealing, they found a nexus based on 3 controlled buys, 2 originating from the target premises, and a 3rd terminating at the target premises. It seems like that's our scenario here.
Well, Your Honor, I think that when we're talking about the probable cause analysis, when it starts with an informant just saying, hey, I bought some drugs from this guy Flacco, and then you know, you have to start the analysis with that. That's where the police first get their information as far as the affidavits are concerned. So if we're starting with that and the informant is flawed and the police cannot establish by independent information that the informant is otherwise reliable, which they couldn't because other than the 3 buys initiated, and we call them buys, but again, I would stress that we have no evidence showing that an exchange happened at the meetings. They called them, they said they met up. They didn't say they saw an exchange of drugs. So when we have an informant that's already unreliable and no other information to establish the veracity of what the informant is saying, it goes back to that first conversation that the officer has with the informant. I've been buying drugs off of this gentleman named Flacco. Where was the officer going with that when he's surveilling 202 Millbury Street and he's finding no evidence of activity other than the three, and again, we're calling them buys, but I believe meetings between the two is a more apt description of what happened, and that's all they have.
So what's the
So-
closest case you think is the best case for you?
I think best cases for Mr. Garcia are the O'Day case, Upton, where it's established that, one, you need the independent corroboration when you don't have an informant that's otherwise reliable, and two, there's a heightened standard with respect to the information that needs to be provided in the affidavit in order to search someone's home. And those are where I think Mr. Garcia's strongest arguments lie, because what we have here is, as I said, an unreliable informant who the police cannot buttress that informant, the veracity of that informant, but for meetups that we have. Again, police want to call them buys, but why is the affidavit completely devoid of any mention of a handoff or other information that we would typically see in the police report where the police are viewing a drug deal, as they claim to be in this case? I just feel like the affidavit on its face and under a reasonable person's view, there are just too many holes to establish probable cause, because it's missing these basic pieces of information. And again, the officer was free to do that. He felt like he needed to protect the informant by omitting location, amount of drugs, amount of money, information with respect to how the handoff happened. That's fine, but they do it at their own peril. And in this case, I believe that he did it for a magistrate to establish probable cause. Because again, we're calling them buys, but really what we have is a meetup, and then confidential informant who we've already established is not reliable. The police don't even know this person other than... Yep.
Attorney Weber, I'm sorry to interrupt you. This is Catherine Hand again. Can I just, since your time is getting short, ask you one other question? Am I correct that with respect to your argument on the that the verdict was against the weight of the evidence, was that ever raised before appeal? Was there a motion for new trial or anything along those lines where it was brought up?
Your Honor, without having the transcript in front of me, I do believe there was a motion for a new trial. With respect to that argument, the reading of the transcript shows that there was a lot of evidence. For instance, they fingerprinted some of the drugs that they found some of the bags of drugs they found, didn't find Mr. Garcia's fingerprints. They found one piece of electrical tape that an officer couldn't explain what it was attached to with a fingerprint of Mr. Garcia's, but then they failed to test any of the other evidence that was picked up at the scene for fingerprints. They failed to check the phones to whose name was on the phones, what contacts were in the phones. They didn't even bother to ask the landlord who was renting the apartment, even though they admitted, every officer admitted that these were things that should have been investigated and would have led to more facts. They just completely ignored all of these different roads they could have went down with respect to investigation to find out if Eduardo Rodriguez owned the drugs and not Mr. Garcia. If those were his phones, if he was the one renting the apartment, if he, if it was his phones, if it was the apartment, if it was his handwriting in the drug ledger, none of that was investigated. Found Mr. Garcia in the apartment, and they honed in on him, and that was it. And I think that, given that, I think that plenty of, it was certainly against the evidence, because all they had was him in the house and fingerprint on a piece of electrical tape. So how do you...
I don't see that there was a motion for required finding of not guilty, and Commonwealth says there wasn't one. I'm just doing a quick search of the transcript. Do you have a reference to establish that one was filed?
I do not, Your Honor, and I think if, in lieu of the fact that one wasn't, I think that this court may take up the issue on plain error review, and I think that, no, I do believe there was error in not in the verdict, given all of the other avenues of evidence that just weren't explored, and essentially three factors pointing to Mr. Garcia when there was maybe 10 on the other pieces of evidence on the other side that weren't even bothered to be tested for fingerprints. Once they realized they weren't finding Mr. Garcia's fingerprints on the bags that they tested, they just stopped testing everything else. I believe at this point,
Mr. Weber, I see your time is up. Let me see if there are further questions from my colleagues. Seeing none, thank you very much for your argument. Weber? Ms. King, when you're ready, you may proceed.
Yes, good afternoon. May it please the court. Michelle King, Assistant District Attorney for the Commonwealth. The motion to suppress was properly granted because there was sufficient evidence to issue the search warrant. When looking at a search warrant application, we look at it in a commonsensical manner. We don't look at it hyper-technical sense. We view the four corners of the affidavit to see, is essentially there a nexus? Are the items sought reasonably expected to be in the search placed? Here we're talking about information that came in part from a confidential informant. And so we have to look at the knowledge and the veracity of that confidential informant. In this case, when looking at the knowledge, we have the personal knowledge of the CI who told the affiant that he or she had purchased drugs from Flacco on multiple occasions. We also have a specific description of Flacco given to the affiant by the confidential informant, and it was quite specific. It was a light-skinned male, thin, 5'8", 150, around 40 years old, short dark hair, and went by the street name of Flacco. I would suggest to you that there was sufficient information as to the knowledge prong of this test. With regard to the veracity, confidential informant in this case was a known and identified person. The police officers involved knew the address of this informant and had met with this informant on several prior occasions. In addition, the search warrant application, the affidavit stated that this informant had a reasonable fear of prosecution because he or she was a known drug user. Even if this court were to consider that the knowledge and veracity prongs of the test were not met, there was more than sufficient evidence in this case of further corroboration. There were three controlled buys in this case that established a nexus between the address at 202 Milbury Street and the fact that contraband would be found there. Specifically on the first.
Attorney King, this is Judge Henry. Does the affidavit in support of the search warrant application allege that the confidential informant had provided reliable information on even one prior occasion?
I don't believe it did, Your Honor. I believe that it just said that the informant was a known person with an address and they had met before, but I don't believe that it did say that they had provided, that he or she had provided that information in the past.
And in terms of getting to whether we have 2 or 3 controlled buys tied to the residence, on the first controlled buy, they don't follow Flacco back to the apartment. They just say that, quote, a short time later, that the vehicle was observed back at the target location. Is there any boundary on what a short time is? I'm reminded of the quote that the days are long, but the years are short. So I don't know what a short time means.
Well, the days are shorter this time of year, that's for certain, Your Honor.
That is,
There was no, so my read of the record was not that there was a time indicated as in 1 or 2 hours, but a fair reading from the record is that it was later that day. I think if you read the transcript carefully, if you read the affidavit carefully, I think a reasonable inference is that it was later that day. Whether that was 1 or 2 or 3 hours was not, to my knowledge, was not specifically stated in the affidavit. We have on that first control buy, we have Flacco being seen at the place of sale in the Camry. We have the sale taking place, and then we have information from the affiant that it appeared that Flacco was trying to drive in a manner that was in a manner of counter surveillance, and so they made a determination not to follow him at that time so as not to give up the confidential informant. And so then a short period later, again, I can't say if that's 1 or 2 or 3 hours later, that Camry was seen at 202 Millbury Street. And then we have the 2 subsequent buys in which the confidential informant reached out to Flacco, who then left, on both occasions, left the apartment, was seen exiting a specific door within the inside of the apartment building that was able to be seen through a window. He was seen then exiting the apartment building, walked to the meeting place with a confidential informant. Now, the confidential informant was searched ahead of time, was given a certain amount of money, was searched ahead of time. There were no drugs on that confidential informant. The informant met Flacco. The informant came back with a certain amount of heroin, which was subsequently determined to be heroin. It was field tested, and the officer testified that it appeared to be heroin. And Flacco was observed.
Was the informant in view of the officers at all times?
Yes, he or she was.
What are we to make of the fact that there's no statement that the officer saw some sort of exchange or handoff?
Well, I don't know if that was an omission on the part of the officer, Your Honor, or not, but I don't think that that's fatal to this analysis, as fatal to this analysis as defense counsel would have you believe, because you have the informant who was given a set amount of money, was observed the entire time up to the meeting with Flacco, came back from this meeting with Flacco, was observed the entire walk back to the officers, and had a set amount of heroin and met with nobody else along the way. So the reasonable inference certainly is that the drugs that were on the confidential informant came from Flacco. And then we have Flacco walking directly back to the apartment building, meeting with no one else in between, going into the apartment building, out of sight for no more than 5 seconds as he walked up the stairwell, and then was observed going back into the apartment. And those 2 control buys were essentially the same. And based on that, there's more than sufficient evidence to establish a nexus between the drugs that were purchased and the apartment building. Now, defense counsel talks about the car and why didn't they get a search warrant for the car? And the reason for that seems obvious, which is that he on only that first occasion used the car, and as Your Honor has pointed out, wasn't observed the entire time. The nexus is not to the car because on the two subsequent buys, the defendant walked to those controlled buys instead of using the car. So the reasonable, again, inference is that the drugs came from the house and not from the car. So I would suggest to you, even if the knowledge and veracity prongs were not met, there was more than sufficient evidence to support this search warrant affidavit, given the strong police corroboration.
Is Claygon your best case?
I have Claygon, Your Honor, and then there are a number of cases sort of in that line of cases. Claygon is certainly the Supreme Judicial Court case. There's also Commonwealth v. Montero, Commonwealth v. Cologne, Commonwealth v. Santiago, Commonwealth v. Luffy, are all cases that talk about controlled buys outside of the house and a reasonable nexus to the house based on the defendant leaving the house just before the controlled buys and then returning back to the house.
Would you agree there's no statement from the confidential informant that he ever saw drugs in the apartment?
I would agree with that, Your Honor, yes.
What are we to make of the fact that it seems like the officer or detective was surveilling the apartment for a significant amount of time and does not ever report seeing either a transaction there or short trips that would be consistent with the drug delivery service?
Well, Your Honor, Commonwealth v. Hardy instructs us that that's not fatal to the search warrant application because, and I quote, the fact that the police never observed short-term visitors or other evidence of drug transactions at the defendant's house is not fatal to probable cause because the defendant's usual method of operation was to deliver drugs away from his apartment. So the fact that the police didn't observe short-term visitors at the apartment, I would suggest is not fatal because the defendant's mode of delivery of drugs was away from the home.
So
There are no further questions. Oh, I'm sorry.
I know the medium is hard. What are we to make of the fact that there was identification in the defendant's apartment in the name of this Rivera, but that it had someone else's picture on it, not the defendant's?
There was not a driver's license in the name of Rivera found, Your Honor. It was a driver's license. The documents that were found were a Social Security card in the name of Rivera, a National Grid bill in the name of Rivera, a Charter Communications bill in the name of Rivera, a driver's car title in the name of Perez, and a driver's license in the name of Perez, but it had the defendant's picture on it. There was no driver's license found there in the name of Rivera. That's inaccurate, Your Honor. And so, but Sergeant Supernor did testify as an expert in this case, and he talked about drug dealers essentially using pseudonyms as a way of avoiding arrests and whatnot. And so the fact that the defendant was using several aliases, I would say would go to that piece of sufficiency evidence. If there are no further questions, I'll rely on my brief.
Seeing none, thank you, Attorney King, and thank you both for accommodating our desire to complete the case today and doing it via Zoom. Attorney King, I hope you're feeling